Welcome to the December 16th, 2020 Board of Zoning Appeals meeting. Certainly glad to have you here. I'm Tim Beavers, the Director of Development Services for the City of Bristol, Tennessee. At this time, I will take roll call. Dustin Goforth.
Here.
David Rudd.
Present.
Joel Staten.
Present.
Katie Steigers.
Present.
Looks like we have all the members present, and thus we have a quorum. At this time, I would like to ask City Attorney Danielle Smith to discuss the necessity for conducting an electronic meeting. After her discussion of it, it would be appropriate to get a motion and a second to conduct the meeting, and then we'll do a roll call vote after that. Danielle?
Thank you, Tim. Members of the Board of Zoning Appeals, typically municipal boards are not allowed to meet electronically. They must meet in person. However, Governor Lee has suspended the provisions of the Open Meetings Act to the extent necessary to allow municipal boards to meet electronically during the COVID-19 pandemic. One condition of meeting electronically is that if you are attending by audio only, that is, nobody can see your video feed, you should identify yourself by name and position when you speak so that the public can understand who's speaking. In order to proceed with meeting electronically, the Board of Zoning Appeals should make a determination that meeting electronically is necessary to protect the health, safety, and welfare of Tennesseans in light of the COVID-19 outbreak. So at this time, it would be appropriate for you to discuss that. And then, as Mr. Beaver said, somebody can make a motion that it's necessary, and you can proceed with a roll call vote. A motion and a second, and then a vote on that.
Any discussion from the board members? Any questions of Danielle on that? If none, then do I have a motion to conduct the meeting electronically?
I will make the motion to conduct the meeting electronically, Mr. Beavers.
Do I have a second?
I will second it.
David Rudd, second. Roll call vote here. Dustin Goforth.
Or Peter.
David Rudd.
Approve.
Joel Staten.
Yes.
Katie Steigers.
Yes.
All right, thank you all. Next, I would like you all to, if you could, just the board members introduce yourself briefly to each other, maybe give a little background of that, and then I'll introduce staff. Once again, I'm Tim Beavers, the Director of Development Services for Bristol. Been in that role for 29 plus years, or not in that role, but with the city for 29 plus years. Started out as the city engineer and now the Director of Development Services, which is Community Development and Public Works combined department. So appreciate you all entertaining me today, listening to me. So with that, one of the board members, just somebody start, and a brief introduction would be good.
I'll go. I'm Joel Staten. I'm retired from Bristol, Tennessee Central Services. I'm a past city council member and a past mayor. I've been on planning probably 14 to 15 years now. On BZA, probably a year or 2 years. I can't remember. And looking forward to serving with you all.
Okay, I'll go next. Hi, everyone. I'm Dave Rudd. I've officially been a homeowner in Bristol for the past 3.5 years. But up until June of this year, when we retired, we're now full-time living in the great city of Bristol. And since we've been there, we've been involved with the Bristol Pirates that was over in Bristol, Virginia. And we were a host family for a couple of players for a couple of years. And that was a real great experience. And we're going to be doing that again this year. They're going to change the league to a college league. So my background, I've had experience in the private sector, the public sector, the military. I have 23 years in the Navy, and I retired as a Master Chief Petty Officer in 2006. And then I worked in for a contractor for the federal government, and then I got hired by the federal government My job, well, I was director of training in many different organizations. I worked for Customs and Border Protection Agency, the Department of Navy, Department of Agriculture, and then finally with the Department of Justice. And my final title, it's really long, but it really wasn't that important. I was the acting Deputy Assistant Inspector General for Management and Planning. So that's how I went out, and I'm enjoying retirement. And even though I'm retired, I still do have one teaching gig. I teach online at public service. I'm really looking to working with all of you.
I think his connection is a little slow there. Dustin, you want to go next?
Yeah, I'm Dustin Goforth. Lived in Bristol for a little over 10 years. I currently serve on the Bristol YMCA Board of Directors. I have two boys that go to Haynesfield, second grade and kindergarten. Previously to doing what I do now, I worked in the state Senate in Nashville for a couple of years, and then joined the government relations team for what used to be Mountain States Health Alliance. From there, I went 10 years at a law firm in Nashville, and then broke out and created a business of my own called Capital and Fifth Public Strategies that I run with a business partner out of Nashville. It's a statewide public strategies business. Other than that, glad to be here and glad to serve.
Katie?
Good morning. My name's Katie Steigers. I have also lived in Bristol around a little more than 10 years, maybe 12 years. And this time I came to Bristol originally as a college student, went to King College. I grew up outside of Atlanta, Georgia in Stone Mountain. Came up here to play soccer for a few years. And eventually after grad school, decided I wanted to move back. We really liked it and wanted to raise our family here. So I currently, for work, I'm the Vice President of Research for FAHI, which is a community development financial institution based out of Berea, Kentucky. We primarily work with housing finance, and we're a membership organization with members throughout Appalachia. Before that, I worked for the YWCA and also Virginia Intermont. I'm a past board member at Believe in Bristol, and have really enjoyed just being a part of the community. I coach soccer. My kids are in 8th grade advance and 6th grade at Fairmount. So really excited to be here with you all. My interest in planning and zoning is partly related to my education. My master's degree was in urban affairs and took a lot of courses in city planning and land use. It's something I follow pretty closely as sort of a lay person here in the city, and wanted to get more involved. So glad to be here with you all.
Thank you. Carrie, we'll hit you up first from a staff perspective.
You want me to talk about me?
Yes.
I'm Carrie. Oh, okay. Did it catch up?
You're good.
Okay, I'm staff attorney, and I am from
I'm not sure that's going to work.
Yeah, no, I don't think it will.
city, but I've been with her. Sorry.
Anyways, Carrie is our staff attorney. She's been with Danielle. You can probably tell more about Carrie than I can.
Yes, briefly, Carrie's the staff attorney. She works primarily on delinquent taxes, but she's here because if anything happens to me, then Carrie will be taking over as well. I mean, she will be the person who steps in to deal with immediate issues. So if I, get hit by a bus or come down with COVID, then you guys have a BZA meeting, then it's going to be up to Carrie to provide you guys with some guidance. So, and she'll have a better connection at that point. Sometimes we have some issues with the city Wi-Fi, but.
Sheriff?
Hey, everybody. Good morning. So my name is Sherith Young, and I'm the Planning Services Manager for the City of Bristol. Born and raised in Bristol, spent a little time in Knoxville and Atlanta, and came back 8 or so years ago. I have been working in the planning zoning field for about, I'm doing the math just now, it's about 16 years. It's hard to believe, but have been with the city for about 5, or it'll be 5 this summer. So excited to get to know you all and work with y'all with the BZA.
Ross?
Yes. Ross Peters, I'm the zoning administrator. I've been with the city now for 17 years, I believe. Been in this role now for almost 3. Born and raised in Bristol. Just love being here and working here at the city and with all the great people we have on staff, and just glad to be here.
Thank you. Danielle, you've already introduced yourself earlier, so we'll not let you talk, but just wanted to get to know everybody so you can see the functions that everybody plays. This is primarily who you will see at the Board of Zoning Appeals, anything that when we do other business, when we actually have cases to look at, you will see these faces. They should be, so I just wanted to get everybody familiar with who everybody is and their background. Appreciate you all volunteering to serve on the board, certainly the most of the board members here, and appreciate staff. They do a wonderful job here at the city, so can't praise them enough. The next order of business, and after this, I will turn the meeting over to whoever is appointed chair, but would be the election of officers, and we will start out with the chairman. And do I have a nomination for chairman of the board?
Well, I would like to nominate Katie because she's going to be a member of the board for at least right now for 2 years, and this would give her some leadership position within our board at least one of those 2 years.
Do I have a second on that motion or discussion?
You don't really need a second for a nomination, Tim. They can just vote if they like to, but.
Do we have any other nominations?
Has anyone been on the board before that might want to be the chair this year? Okay.
And that would be the other part is, Katie, I hope you are willing to accept that position if voted on here.
Yeah, that's totally fine. I just wanted to be sure that if there's anybody else who had maybe an interest or wanted to discuss it, we got a chance to.
With that nomination and hearing no others, I'll take a vote. Dustin, go forth.
Aye.
David Rudd.
Aye.
Joel Staten.
Aye.
Yes, Tim.
And Katie Steigers.
Aye.
So Chairwoman Steigers, at this point, and I know you don't have sheets in front of you, so I'll help you through that, but at this point, it would be appropriate for you to ask for nominations for vice chair.
Excellent. Okay. At this time, we would like to we need a nomination for vice chair. Does anyone have a nomination?
I'll nominate David.
Okay, we have a nomination from Joel Staten for David.
It was
Nope.
Dustin.
Sorry.
Go forth. Yeah.
My Hollywood squares are not cooperating with me sound-wise. We have a nomination from Dustin Goforth that David Rudd be vice chair. Does anyone want to discuss that? No discussion. David, would you be willing to serve?
Yes, I accept.
Okay. Then Danielle, I'm trusting you that you'll stop me if I'm doing this incorrectly. We need a vote.
You're doing fine.
Okay, great.
And I can do the roll call for the vote if you would like, Madam Chairwoman.
Thank you. Mr. Beavers will take our votes now on the nomination for David Rudd to be the vice chair.
Dustin Goforth,
Aye.
David Rudd,
Aye.
Joel Staten,
Yes.
Katie Steigers.
Yes.
And then the next item for consideration, Madam Chairwoman, would be the election of a secretary. And the secretary doesn't have to be a board member, isn't that correct, Danielle? It could be staff if you wanted staff to do it. But
The board can authorize staff to perform the secretary's duties. The secretary's duties are keeping a record of all proceedings of the board, maintaining applications, notices, orders, minutes, and other documents relating to the proceedings of the board. So
is there a history of who's typically held that role?
Typically, it has been a board member on both Planning Commission and BZA.
I'd like to nominate, can I make nominations? Sorry.
Yes.
Okay. At this time, we need a nomination for the role of secretary. I'll let y'all make a nomination if you have one. I would like to nominate Dustin Goforth if he's willing to serve.
Yeah.
Does anyone else have a nomination? Okay. No other discussion. Mr. Beavers, would you call roll on the nomination for Dustin Goforth to be the secretary?
Yes, ma'am. Dustin Goforth,
Aye.
David Rudd,
Aye.
Joel Staten,
Yes.
and Katie Steigers.
Aye.
And Madam Chairman, appreciate that. An election of officers, and that is all the official business we have today, unless you all have some questions on that. But if you all deem appropriately, we'll let Danielle Smith talk to you all and get you some training hours in here and talk about training, get you a training hour and session in at this time if that you all deem that appropriate.
Anyone have any concerns about moving towards the training part of our agenda? I do have a quick question. Does Dustin need anything in order to, does he need to take minutes at this point? Or is there any as a template that he should have?
No, we are recording it's on air and it'll be recorded. And then our secretary here at Development Services will prepare the minutes for the next meeting for consideration by the board. So there's nothing you need. Now, Dustin, the next time we have a meeting, I'll have you the little checklist where you take votes on things. I'll have some additional paperwork you'll get to record the votes and roll call and things like that. So.
Okay, great. So thank you. And is there any other questions? Are there any other questions? Okay, Danielle, will you take us into the training portion of the meeting, please?
absolutely. Thank you. First of all, I'd like to say we're at 11:20 now. I'm going to try to do an hour of training, but I would like to be done by 12:20 so that everybody can go about their days. So the reason for the hour will become clear as part of the training. We'll talk more about training requirements. Second, I'd like to say congratulations on being appointed to the board. We really do as a city appreciate your willingness to serve, because this is in many ways a thankless job, as you will hear. But please feel free to ask any questions as we move forward. And please, though, mute your microphones when you don't want to ask a question, because that will cut down on noise and feedback. The training is being recorded so that it can be shared with other members or members of the Planning Commission who might want to get an extra hour of training. The reason for having this training is that 3 of you are new members, and we wanted to provide an overview of what the BZA does so that your first application isn't a complete surprise. And I'm going to stop. Hey, Tim, are you sharing the PowerPoint yet? Am I just not seeing it? Tim?
I didn't see one on my emails. Did you send me something?
I emailed you one yesterday.
Okay.
Did I not?
No, but anyway.
Sorry. Well, that's always good.
But I can
will
run
email
and get
to
it,
Tim
and
right now.
I can run and download it real quick.
You know what? I'll email it to you. I'm sorry,
Okay.
Tim. I swear I thought I had emailed it to you yesterday.
If you did, I missed it. But anyway, I can run it real quick.
Yeah, it won't take long. And really, the PowerPoint is not that exciting. It's just there to give you something to look at other than my face. In terms of what we're covering, there's no fun clip art really that can help you understand the BZA. It is what it is. Give me 1 second while I find it. Unfortunately, I've got so many documents running around that sometimes it can be difficult to track
Is there
down.
a part of our notebooks that we received that we could flip to?
Absolutely. We'll be talking about a lot of the documents that you actually get, that you got. So if you want to follow along, but some of this is just really coming more out of my head, but I'll try to refer you to those documents as we go through. So back to just why we're doing the training. We are really, we want to make sure you guys can hit the ground running when you get your first application. This board handles complicated and controversial matters. So just to let you know that, Joel is nodding right now, and there's a reason for that. So far in my experience with the city, this board is the one whose actions are most likely to end up being reviewed by a court. That's not a good or a bad thing. It's just a fact. You deal with people's property, and that becomes, that can be an emotional experience for many people. So service on the BZA is a big responsibility, and it may not make you popular, but it is a really valuable responsibility. We do value you. The second reason for training is that you are required by state law to do a certain amount of training. We'll talk more about that, but we're going to knock out your first required hour right now. So we would be on slide 2 right now. So I'm just keeping Tim up with where we are in the slideshow. If you look at state law allows the city of Bristol and other cities to create a board of zoning appeals. They can have a varied number of members. The city of Bristol has 5 members on their board of zoning appeals. The first question that probably comes up is, what is zoning? Many of you probably have not thought really about what that term means, but zoning is when a city or other governing body, such as a county, regulates the use of land within the community and of the buildings and structures that may be located on that land, in accordance with a general plan and for the purposes of promoting the public health, safety, morals, convenience, order, prosperity, and general welfare. So in an ideal world, that is what zoning does. State law delegates the power to zone to our city council. The city council acts when it makes zoning and rezoning decisions with the advice of our planning commission, which is another body that's established by state law. City council usually adopts zoning ordinances after a planning commission has reviewed them and made a recommendation one way or another. In practice, the planning commission spends a great deal of time working on regulations before they ever get to council. So again, the planning commission is another body that really, oh, thanks, Tim, sorry. You can go forward to slide 2. Oh, nope, back up 1. There we go. Yes, that's right. No, I think that's actually slide 3, isn't it? At any rate, we're good. So the thing to take, nope, sorry, go back. There we go, stop. The thing to keep in mind is that the planning commission and the city council are the legislative bodies. The BZA doesn't make regulations. You serve more as a judicial body that interprets those regulations and applies those regulations. So now we can move to the next slide. As I say, the BZA has a quasi-judicial function. You are very similar to a court in how you act. You interpret existing regulations and statutes, and you weigh facts and evidence to determine whether someone should get relief. This is similar to how a court functions. If you think of local government as having a legislative function that's city council and planning commission, an executive function that's the city manager and staff, and a judicial function such as our municipal courts, the BZA fits more within that judicial function than elsewhere. So because you have that judicial function, the thing to keep in mind when making decisions just from a 1,000-foot level is that you should not be considering the people before you so much as the properties and the laws before you. So the character of the applicants or opponents of the applicants or of anybody else coming in as a witness is not really relevant unless it goes to their credibility. When you make decisions, you should not be considering race, religion, sex, sexual orientation, or any one of the other Title VII criteria or qualities that we talk about. You shouldn't be considering political leanings or socioeconomic status. You shouldn't really be considering neighborhood opposition to or support for an application, though you can consider facts that are raised by someone who comes to a meeting, as long as they are the facts and not just emotional statements. Your own personal likes and dislikes are not relevant in a BZA hearing. And I think, as I referred to before, BZA hearings often have a clear winner and a loser. And so this can really put you guys in the hot seat because you're the ones making that decision. You are not trying to decide whether you like a proposal. You're trying to decide whether the facts and the law support granting an application or denying it. If you will probably, in your service on the BZA, find city ordinances that you don't agree with. And so even though you are bound to apply those ordinances as written, you can also express your views on them. So if you find an ordinance that you don't agree with, it is permissible for the BZA to say to staff, staff, this doesn't make any sense. Can you talk to the Planning Commission about changing that? And that's actually happened in the past. Just last year, the year before, the BZA found that they couldn't grant a variance to the driveway access regulations, but they did call Planning Commission's attention to the fact that the driveway widths as written didn't really work. And Planning Commission and City Council then went on to change those. The thing to remember, though, is that you are still bound to follow adopted ordinances and state laws, even if you don't agree with their impact and effect. So next slide, Tim. So as you know, members are appointed by City Council. They can be removed by City Council for cause. Cause would be something like failure to accomplish your training or failure to come to meetings. If you're absent from 3 consecutive meetings without good cause, you can be deemed to have resigned your position. Your board members serve 5 staggered terms. So 1 member's term is required to expire each year. That is something that state law put in. I'm not entirely sure what the reason for it was, but while members can be appointed, they can be reappointed indefinitely. There has to be 1 member coming up for reappointment each year. So City Council adopted a resolution that basically determines whose terms will expire. And I think you guys have all seen that. Joel at this point is ending on September 30th, 2025. David Rudd is 2024. Dustin is 2023. Katie is 2022. And then whoever gets appointed to the last spot would expire on September 30th, 2021. That'll keep you guys on that staggered schedule going forward. The annual training requirement, within the first year of your appointment, and then in each calendar year thereafter, you have to complete at least 4 hours of continuing education. And the subjects are land use, planning, zoning, floodplain management, subdivision, agricultural land conservation. It's all laid out in the statute. And I believe that statute is 137-205. I think it should be in your packet if you want to look at that. So since you have that, I'm not going to read all the subjects of training. You have a little flexibility. If there's other topics that you want to hear about, then the board can find that those topics are relevant to your training. You have to keep records of your training. The city is obligated to pay for the expenses of your training. Now, practically, what happens if you go to training or if you attend training such as today's training, the city staff is going to keep a record of that. And practically speaking, staff is maintaining those records. But don't forget that the statute puts the obligations on you to do the training and to make sure that you've got records showing that you have done the training.
Danielle, can I jump in real quick?
Sure.
And what we do as staff, each month we will send out a spreadsheet showing your training hours. Plus, we'll put on there opportunities like online opportunities, Zoom opportunities. We do have an opportunity coming up Monday night if you all want to watch it live, or it will be recorded and can be played back for some training that's going to be given to the Planning Commission on property rights. But the staff, what we do is we'll provide you monthly with the training hours as you all have reported them and opportunities for y'all to get training. So that it's in front of y'all. Y'all don't have to search. Certainly if y'all find something out there, if you can send us the links, then we'll make sure everybody has it, that opportunity. But we will try to keep up, we will keep a spreadsheet and tally, and we'll try to keep that in front of y'all every month, just so you know where you are. The board doesn't typically meet often, unless sometimes it seems like we meet every month, but it was about a year between meetings. We had one back in June, but it was about a year prior to that when the board met. So we do not meet frequently, because it's just really if somebody has an appeal to the zoning ordinance or something staff has interpreted to the zoning map or zoning ordinance.
Tim, you're now getting into the rest of my training.
I know. So, okay, I'm done. Thanks. Just the main thing, staff will keep opportunities in front of you and keep up with your hours as you report them. Thank you.
And Tim's right. While you guys have the statutory obligation, staff is really here to help you. You're very lucky because Bristol has a very talented planning staff, and they take this advisory role. They may make recommendations as to the correct course of action, but something to remember is that those recommendations are not binding on the BZA. You are free to disagree with staff. Probably a good idea if you can articulate reasons for disagreeing with staff, but that is within your purview to disagree with staff. My role, briefly, as city attorney, I serve as advisor and counsel to the staff and to the board. I can answer questions from you during meetings. I don't argue on behalf of people who are appearing before you. They are free to bring their own attorneys, and those attorneys can make arguments on their behalf, or they can argue themselves without an attorney. The reason for that is that I'm basically going to be responsible for handling representation of the board after the fact. And so if someone disputes a finding of the board, which happens, either I'm going to represent you, or we're going to get insurance to find an attorney to represent you, and I'm going to guide that attorney in representing you. So I need to be able to argue that your position was correct, which means that I can't really get up in front of the board and say that you were wrong. And so that's why during a meeting, you're not going to hear from me unless you ask me a question about if you have a question about how to interpret a statute or a regulation. I'm happy to give you that advice, but I don't usually argue one way or the other. So the next slide, Tim. As we just talked about, really the BZA only has the power to hear certain kinds of cases. And so those cases there's 4 different kinds, 3 of them on this slide. BZA hears appeals from administrative decisions, and administrative decisions are staff decisions. Anytime and again, you can follow along in the statutes, anytime there's an allegation that there's error in any order, requirement, permit, decision, or refusal by any administrative official in carrying out the zoning ordinance. Most often, this takes the form of disagreements with how staff has interpreted the language of the zoning ordinance. So from examples, staff may tell somebody that a particular use is permitted in a particular zone or is not permitted in a particular zone. Staff may determine that a site plan has to be submitted, or that the site plan has to be a particular kind of site plan, and before a project can continue, and someone could take exception to that. The BZA also has the power to hear requests for special exceptions. And right now in our zoning ordinance, the only special exception that we lay out is wireless transmission facilities. So if someone wants to come in and put a wireless transmission facility in, they need to apply for a special exception, and the BZA would hear that. I'll be honest, that has not happened in the 5 years that I've been with the city. So we'll keep our fingers crossed that it might happen again. It'll be exciting for all of us. The BZA also has authority to interpret zoning maps and pass upon disputed questions of lot lines or district boundary lines or similar questions. Again, this is not something that we commonly see. The administrative appeals are very common. And then the next slide shows the thing that the BZA probably hears the most. The BZA has the power to grant variances from strict application of the zoning ordinance. Now I have laid out here the conditions under which you can grant a variance, just so that you can start to become familiar with them. These conditions will be provided for you anytime there's an application for a variance, but these conditions are laid out in state law again. So your power to grant a variance, and just to explain, a variance means that you are deviating from the rule laid out in the zoning ordinance. For example, if someone says, well, I can't build my house where the setbacks say I should build it, and so I want to be able to build it closer to the road or closer to the rear of the property, that would be a variance. They'd be asking for the setbacks to vary for their property when they don't vary for other properties. So in order to grant a variance, the BZA has to find that these criteria laid out on the slide apply. Those criteria include exceptional narrowness, shallowness, or shape, exceptional topographic conditions, or other exceptional extraordinary conditions. And there has to be peculiar and exceptional practical difficulties or undue hardship to the owner. And there can't be any substantial detriment to the public good. And the variance has to be able to be granted without substantially impairing the intent of the zoning ordinance. The variances are fairly common. Those in administrative appeals are the things that the BZA is going to hear the most. We have adopted BZA policies. We'll talk more about those later. You've got copies of those. In the policies, the BZA went ahead and laid out that they will not hear an application for a variance when the variance is asking for a use that's not allowed or an exception to the density that's allowed. The reason for that is if you look at these criteria, it's clear that they relate to the property itself. We're talking about topographical conditions, conditions of the land itself. Use and density are not things that relate to the land itself. So one thing that you'll notice is that in general, there's not going to be any opportunity for the BZA to hear an appeal from the Planning Commission, and you certainly are not going to hear an appeal from decisions to City Council. It's difficult to think of a circumstance where the BZA would hear an appeal from Planning Commission, but as you can see, most of the things that come to the BZA are things that are laid out in the zoning ordinance as being for BZA to hear, or they are decisions of staff that the BZA has the ability to appeal. So are there any questions so far? Okay, we'll continue to the next slide. So who is coming before the BZA? The statute talks about an aggrieved person being able to file appeals to the BZA. Typically, that's going to be obviously somebody who is denied a permit under the zoning ordinance, somebody who thinks that the staff made the wrong decision when they told them they couldn't use their property for a particular use. Person who submits a site plan and staff won't approve the site plan. The surprising thing, though, for many people is that it's not just property owners who can be aggrieved and file appeals to the BZA. Neighboring property owners can be aggrieved, and even people who live on the next block can be aggrieved. The statutes, any person aggrieved is a very broad term. The only case law that we see on that basically says that there's not much stopping that bubble of who's aggrieved. There's even a case where the city of Brentwood actually sued. Well, they actually took a case to the city of Nashville's Board of Zoning Appeals after the city of Nashville granted permission for a billboard to be located right on the border of Nashville and Brentwood. I guess it was facing into Brentwood, and Brentwood didn't like it. They thought it would make their city look tacky to have this billboard on the Nashville side. And so the city of Brentwood filed an appeal to the Nashville Metropolitan Board of Zoning Appeals. And then when the Metropolitan Board of Zoning Appeals did not find in their favor, the city of Brentwood took them to court to get the decision of the city of Nashville's Board of Zoning Appeals overturned. And the court said that they had standing in both cases to file that appeal to the Board of Zoning Appeals and then to file the appeal from court to the court. Even the city can file an appeal of a decision of a city administrative official to the BZA. So, for example, if sheriff tells another city department that they can't use property for a particular purpose, that other city department could file an appeal to the Board of Zoning Appeals. As far as I know, it's never happened, and I would be surprised if it ever did happen, but the statute does talk in terms of the city itself having that right to appeal to the Board of Zoning Appeals. So moving on, those are things that are really covered in the statute. The BZA, about probably 3 years ago, adopted policies and procedures. And you'll notice if you compare your bylaws to your policies and procedures, the bylaws cover things like when you guys meet. They cover the quorum, which is 3 members. They establish the officers. They set the order of business. These bylaws are a little canned. They really are not that different from any other board's bylaws. They're very, very straightforward. The reason for the policies is that BZA does things that other boards don't do. And so staff and BZA 3 or 4 years ago really reached the conclusion that we needed policies to flesh out those BZA activities in a way that didn't contradict state law or the city code. And so as we walk through these policies, I would encourage you to pay close attention to them. They are your policies. The BZA is free to modify these policies in a way that doesn't contradict state law. You just need to have that discussion at a public meeting and make that decision in public, and you are free to modify the policies. I would probably encourage you to get through a couple of hearings first and then see if you think there are things that need to change. Just roughly in order, if you're following along with the policies, and I'm afraid I don't have that document open because I've got too many documents open on my laptop right now anyway, but one of the things that the BZA's policies cover is the notice requirements. So when a request for a variance or a special exception is filed, staff is directed to send written notice to affected property owners at least 15 calendar days before the variance is heard by the board. An affected property owner is defined by the policies as being the owner of any property that lies within 200 feet of the property that's the subject of the application. So I think the goal of that policy is to make sure that anybody who could be interested in this variance or special exception has the opportunity to appear and make their concerns known to the Board of Zoning Appeals. The policies also set time limits, particularly on appeals of decisions of staff, of administrative staff. Because we don't want things sort of lying out there for years, we ask that applications be filed within 60 days of the decision. So if someone receives a decision from the zoning administrator that a particular use is not allowed on their property and they want to appeal that, we would ask them to submit that within 60 days. Once it's received by staff, that really, as Tim alluded to, the Board of Zoning Appeals does not meet every month. You guys meet as needed on a set day. So then once we've got the application from somebody, we can decide whether we need to have a meeting the following month, or we can notify Board of Zoning Appeals members if there will be a meeting. This also gives staff some time to analyze the application and provide notice to any affected property owners. One thing that we've established in the policies is that the applicant or their representative must be present. There's a reason for that. It's because if the applicant is not present, they can't make any arguments on their own behalf. And there's nobody else there to argue for them unless they're already agreeing with staff, which seems unlikely in the sense of an administrative appeal. You guys really need to hear from that applicant to know what their arguments are so that they really get a fair hearing at the BZA. If they can't be there, then the hearing should be postponed, or if they just refuse to be there, perhaps you dismiss it. The policies allow for both of those things. I threw a legal term in on the screen just to keep everybody on their toes. I don't know if anybody has ever heard the term res judicata before, but it's basically means that things that have been decided stand. So there's no second bites at the apple before the Board of Zoning Appeals. If somebody has already brought a matter to the Board of Zoning Appeals and the Board of Zoning Appeals has made a decision, it does not come back to the Board of Zoning Appeals. The appropriate remedy in that case is to go back to court, or to take is to go to court and have a court review it. There's an exception laid out in the policies for when the Board of Zoning Appeals finds that its decision was based on false information. So again, this is not something that's ever happened. It's something that when drafting the policies, the Board of Zoning Appeals allowed for that possibility that you guys might make a decision and find that you didn't have the information or you had false information. In that case, you would be able to rehear a case. Otherwise, you don't rehear cases. Ex parte contacts. This is a little bit of I think this goes back to you guys being a judicial body versus a legislative body. Ex parte means that you're outside the presence of all the parties to a case. And so if you're appearing before a judge, one thing you don't want to hear is that your opponent in court, say you're defending a lawsuit, you don't want to hear that the plaintiff has had the opportunity to talk to the judge and make their arguments without you being there to hear them and address those arguments. Parties before the BZA really deserve the same respect. And so when it comes to BZA hearings, you all should not have contact with people who have an interest in the case prior to the public hearing. It raises questions of fairness and due process when you do that. And so the policies encourage you to avoid ex parte contacts with anybody who's interested in the case. And if you do have ex parte contacts, to come to the board during the public hearing and say, well, I spoke to so-and-so, they are not here today, but they live, across the street from this property. and they had this to say. And once you do that, once you share those contacts and the information that you learned from that contact with your fellow board member, all of the members can then make a decision that takes that into account if they wish. A similar thing that arises is whether or not you should make site visits. And the way that the policies address that is that site visits are not prohibited. And in some cases, it may actually be very helpful for you to go out and visit the site. But when you visit the site, you shouldn't really make yourself available to anybody to make arguments to you. Anybody that contacts you about it or that you run into should be encouraged to come to the public hearing and speak to the entire board. And if you learn things at your site visit that inform your decision making, you should bring it up to the rest of the board. And again, it's so that the rest of the board has all of the same information that you do, and they can make a decision based on all of the same information. If you have information that is influencing your decision and you don't share it, then again, it raises a question of how fair the hearing is. If you need additional information about a case, and so suppose that we have an application, you guys all come to the meeting, none of you have made a site visit, and you say, you know what, it would really help us if we went out and saw this site. It is permissible for you guys to suspend your consideration of the case to your next meeting or to another time and to go out and visit the site, or if it's other information that you need, to direct staff to find that information or to direct parties to bring that information to you at the continuation of the hearing. The next slide, Tim. Briefly, we're going to run through how the public hearing actually works. And again, this is really more so that when your first public hearing happens, you're not going to be completely blindsided. One thing to note, though, before we get into how to conduct a public hearing is the difference between a public hearing and a public meeting. So a public meeting is a meeting where the board takes actions and deliberates, and that needs only be open to the public. This is a public meeting, for example. You all have taken an official action today by voting for your new officers. This meeting is open to the public, and the public is free to watch live or watch the recording. A public hearing, on the other hand, where a public meeting needs only be open, there's no participation required by the public. A public hearing is an opportunity for an applicant and other interested parties to actually participate. They get to present argument and evidence on a matter before the board. When we have a public meeting of the Board of Zoning Appeals, it could be made up of one or more public hearings on different matters. So typically, your meeting will start the same way today's meeting did, with a roll call. And if we're meeting electronically, which I sincerely hope at some point we will not be meeting electronically and we'll be able to meet in person, we'll talk through the necessity of electronic meetings. You'll cover any old business, you'll approve your minutes, and then you'll open your public hearing on the first case that's before you. When the chairperson opens the public hearing, this first thing that they'll do is call on staff. At that point, staff presents its analysis, including any recommendation that staff is going to make on this. Staff is always going to do a written staff report, which you will have before the meeting starts. And so a lot of times what is presented at the public hearing is going over a written report that you've hopefully already read and digested. And again, you don't have to agree with staff's recommendations. If staff was infallible, there wouldn't be a need for a BZA. So just to keep that, I'm going to keep emphasizing that because I think it's very important for you to understand that. After staff has made its presentation, the applicant, whoever that is, who's the person who's asking for the BZA to consider the matter, presents its case. And I say it's because frequently we do hear from businesses and not just people, but it could be a she or he as well. Then any opponents present their case for why the relief should not be granted. Either side can have witnesses appear. And typically what the board has allowed is they've allowed anybody who shows up to the meeting to have the opportunity to speak. The board, though, has the authority to impose time limits. So you don't have to allow everybody to speak for an unlimited time. You can say at the beginning that you feel like people should be able to limit their comments to 5 minutes. The board can also ask any questions that it wants. The goal of this public hearing is for you to gather facts so that you can then make a decision based on a reasoned basis. Once you've heard, and Tim, to go to the next slide. Once you've heard from everybody who's interested in speaking or that you are interested in hearing from, the chairman can close the public hearing, and then the board proceeds to its deliberations and discussions. The chairperson can vote and should vote. So just to be clear, there's a lot of times that people have different understandings of what Robert's rules allows in terms of voting by the chairman. The addition of Robert's rules that I go by definitely allows the chairman to vote. And so the Board of Zoning Appeals is no different. The chairperson of the Board of Zoning Appeals should definitely vote. And I think that if nobody else is making a motion, the chairperson actually can make a motion as well. There's nothing to prevent that. The bylaws have adopted Robert's rules, and they're used in a slightly modified fashion, more by tradition than anything else. Again, just going briefly through, once the public hearing has been closed, then the board has to take up the matter. And so typically there could be some discussion and deliberation among the board members. The strict interpretation of Robert's rules is that there needs to be a motion first before there can be discussion. But I don't really want to get too hung up on strict interpretation of Robert's rules, because your goal as the Board of Zoning Appeals is really to get to a conclusion. It's not to use parliamentary procedure to hinder or hamper anything. So while you do need to make sure that there's a motion and a second and then a vote, things like when the discussion occurs, I'm not going to stop you and say, now, wait a minute, you've got to have a motion first before you can start discussing. When you make a motion as a board member, you should make a specific motion. And that's why it can also be helpful to make your motion after there's been some discussion and you've had your thoughts formulated. So a specific motion would be something like, I move to grant the applicant's request for a variance based on the following hardships that have been demonstrated by their application, and then list out the facts that you think support that motion. If someone else agrees with you, they can make a second. You can have further discussion. There can be an amendment to the motion. So someone else could say, I'd like to amend it. I move to amend the motion because I feel like there are other facts that should be considered. Once you've got your motion completely fleshed out, then you can vote on the motion. It's very important for the BZA to really state reasons for its decision beyond just, we think this decision is in the interest of public health, safety, and welfare. You should identify specific facts that support your motion and that support granting the application or denying the application. Once you've done that, that gives everybody the opportunity to review your findings of fact and to figure out whether they want to make an appeal from the Board of Zoning Appeals decision, or whether they're just going to let it rest. And Tim, can we move on to the next slide? So things to keep in mind, BZA meetings, including this one, are recorded. The reason for recording primarily is that if litigation arises, we need to be able to produce a transcript of the public meeting and of the hearing at which, so if somebody decides to take their case to court, we'll produce a transcript that literally says who said what at each time during the hearing. Something else for you to keep in mind, particularly for the chairperson to keep in mind, is that the BZA is responsible for maintaining the decorum of meetings, both for themselves and for members of the public who are in attendance. One of the roles of the chairperson is to maintain that decorum. And, as you probably can imagine, sometimes hearings before the BZA are contentious, but as chairperson, you do not tolerate profanity and personal attacks, or you should not. You are free to remind members of the public that they do not have a general right to speak. They can speak only when the board has opened up for public comment and only when they're called upon. And believe it or not, we do actually have hearings where people are trying to speak out of turn. The chairman can have someone removed from the meeting for breaking the rules. So it's a lot of power and responsibility for the chairman, but that is okay. Usually we even have a law enforcement officer who's present or can be called so that if we need to remove someone from the meeting, they can take that step. My advice would be that you warn people. You can make a general warning that this is the kind of behavior that's not being tolerated. And typically you'll know if a hearing is getting to that point where it's contentious. And then once you've made that warning, people can be removed. We have, one of the things that our policies lay out is that the board signs a record of action form. It's just a simple form that basically summarizes how the members voted, and it indicates how each member voted. We then take that record of action and provide it to the applicant and any party that has appeared before the BZA, so that they then, that starts their time frame for getting the courts to review the BZA's decision. The state law that allows for BZA decisions to be reviewed by a court says that those filings have to be made within 60 days. And so we argue that that record of action, once it's provided to an applicant, starts their 60 days. And so after the BZA decision, as you've heard already, aggrieved parties have the right to judicial review in Sullivan County courts. They file something called a petition for writ of certiorari within that 60 days, and then a court decides whether there has been any arbitrary, capricious, or unsupported action by the BZA. The court generally can uphold the BZA's decision or can send the case back to BZA for rehearing, usually with some instruction about whatever error the court feels the BZA made. One thing that you do not have to worry about, and so I'm sure this will be a relief to you guys, is that you probably will never be called as a witness in a BZA case. Like you yourselves are not going to have to come to court and testify about what you thought, because the court is only looking at the evidence that was presented to the BZA. People can't introduce new evidence. The court is limited to looking at the record of what the BZA did and what was before the BZA. So don't worry. I'll have to go to court over the BZA's decision, but you guys won't have to. Okay, next slide. Well, actually, before I move on to the next slide, that's covering BZA statute, BZA procedures. Does anybody have any questions at this point? Or are you guys just trying to, it's a little bit like drinking from a fire hose, I think. You've heard a lot of information. Yes, David?
Yes, Danielle, I do have a question. And this is my first experience on a board like this. But because we can make decisions that could negatively financially impact a party, are we protected from any personal liability, i.e. being sued?
You should be, yes. I mean, you're not going to get sued personally. The Board of Zoning Appeals as an entity gets sued, and the city's errors and omissions policy covers those lawsuits. And so when we get a lawsuit, I hand it over to public entity partners, and they appoint counsel, and they will be the ones who actually represent the city and provide that defense. It's possible maybe for a BZA member to be sued as an individual, but I think there would have to be some pretty terrible behavior to get you there. Mm-hmm. And so mm-hmm. I don't want to say it couldn't happen, but it's very unlikely. The most likely thing is that, and yes, you're absolutely right. The BZA is making decisions that sometimes affect people's property and livelihood, and it can cost money for people. And all that does, it doesn't mean that you shouldn't make a decision one way or another. It means you need to make your decisions carefully and thoughtfully, and with, pay attention to what the law says mm-hmm. and how you interpret the law. But you should not worry about being personally sued too much.
Great. Thank you very much.
Okay. Anything else? Okay. We're going to move on to talk a little bit about some things that are applicable to the BZA and to other city boards and commissions, but things that you need to be aware of. So open meetings. My guess is that Mr. Goforth already is familiar with the Open Meetings Act because he's worked in state government for a while. Open meetings governs how public bodies conduct their business, and cities are public bodies under the Open Meetings Act. So that means that city boards and commissions also have to conduct their business in the public eye. This is part of what we refer to as the sunshine laws. So Tim, we can move on. These slides are a little choppy. There we go. The formation of public policy and decisions is public business and shall not be conducted in secret. And go to the next slide, Tim. What this comes down to is that all meetings of any governing body have to be open to the public. That means that the public has the right to attend the meeting. It does not mean the public has the right to participate in the meeting. The right to participate comes with public hearings, such as what the BZA will hear periodically, or when the governing body creates a right to participate by inviting public comment. The act also only applies to governing bodies when they are meeting. And so what does that mean? And going on to the next slide. This is the definition of a governing body. Any public body with the authority to make decisions for or recommendations to a public body on policy or administration. From that, it should be clear why the BZA is a public body. And Tim, I'm sorry, you can just go through the animation. I think I meant to take the animation out and I didn't. Because the BZA is making decisions on a matter of public policy on these applications that are before you. Those touched on public policy and public administration. So City Council is a governing body. The BZA and other boards and commissions of the city are governing bodies as well. And moving on. The Open Meetings Act only applies when you actually have a meeting. And so a meeting is not every time the Board of Zoning Appeals gets together, believe it or not. A meeting is only when you're convening in order to make a decision or deliberate toward a decision on any matter. Making a decision is basically voting. Voting is when you actually make your decision. Deliberating toward a decision, though, is a little bit broader. And if you go to the next slide, there's more about deliberating toward a decision. The courts have taken this deliberating toward a decision language within the statute, and they've interpreted it for things like examining and consulting in order to form an opinion, weighing arguments for and against a proposed course of action, having a substantive discussion of your positions, or attempting to develop a consensus. So a couple of things to keep in mind. First, go back up, sorry, Tim. A couple of things to keep in mind here. Suppose that Joel, I'm going to pick on Joel because he's been on the board before. Suppose Joel calls me or calls Tim in order to discuss a case that's going to be appearing before the Board of Zoning Appeals. He's gone out to look at the property where the owner is applying for a variance, and he has questions about it. And when he's talking to me or Tim, he gets into it, I just really don't think this variance should be granted. I don't think they've met the conditions. I don't think there's going to be an undue hardship. So the question there is, has he violated the Open Meetings Act? The answer is no, because neither Tim nor I is a member of the Board of Zoning Appeals. When Joel is venting to us or discussing with us, he's not meeting with another member of the Board of Zoning Appeals. He's meeting with staff. And so discussions between members of the BZA and staff are not meetings for the purpose of the Open Meetings Act. But you have to be careful, because if you and another Board of Zoning Appeals member get together and start discussing a case, you may have violated the Open Meetings Act, even though you're not at a formal meeting. So there, the two of you discussing is what makes it a meeting, not the setting that you're in. So an example there would be if members of the BZA meet at a Christmas party and they discuss a case that they're supposed to hear at their December meeting. So if the discussion consists of one member telling the other member, I am not looking forward to this thing on West State Street. I think there's going to be a lot of angry neighbors. It's going to be very contentious. The other member agrees and says, I've already gotten phone calls. And they say, gosh, it's going to be terrible. So has that violated the Open Meetings Act? Probably not, because there's no deliberation there. There's no argument there. But consider if one member says to the other, I've heard from some of the people who live in that neighborhood, and they tell me that the applicant is threatening the neighbors. He's threatening them with harm if they show up to the meeting. I think that's really bad behavior. I'm going to vote against his application. And the other member says, oh my gosh, I'm glad you told me about that. I'm going to vote against that application too. So suddenly we have stepped over the line into a violation of the Open Meetings Act, because there you've got two people. The first member is clearly trying to sway the second member short of taking a position that's adverse to the applicant. And that ends up violating the Open Meetings Act. So you need to be careful as members of the BZA to avoid doing anything that could violate the Open Meetings Act. If you have discussions like that, they need to happen in a meeting that's open to the public. Now, in that case, the second scenario that I laid out, I'm not saying that the applicant's bad behavior shouldn't go unpunished, but if he's threatening to harm people, then the first member of the Board of Zoning Appeals probably should have reported that to the police rather than talking to another member about it at a Christmas party. So what if you guys have already met and voted on something? If you've already met, then it's fine for you to talk about the case afterwards. If you've already voted and made your decision, then you guys can post-mortem all you want. You can have those discussions, but watch out for making statements that about how this case might influence your future vote. So if you start saying, well, based on this, I am never ever going to vote in a way that would grant a variance in this kind of situation again, that's where you can again get in trouble, because you're making arguments for future decisions. Okay, so next slide. All right, can the BZA meet by email? No, email is not a public forum. As I said before, typically you guys are not allowed to meet electronically. We're only meeting electronically now because of COVID and because we've had executive orders issued by Governor Lee that provide exceptions. That's not going to last forever, but we do think that the legislature is going to give, a lot of cities and counties have asked for some relief in this area. So we may end up having the ability to meet electronically or partially electronically at some point. The other thing to keep in mind is that training and information sessions can be held electronically because there's no business being discussed or deliberated during that meeting. So as long as you're just getting information, you can have a gathering electronically and it doesn't violate the Open Meetings Act. So other requirements of the Open Meetings Act, moving on to the next slide. There has to be adequate notice provided of meetings. The statute does not tell us what adequate notice is. It would be kind of nice if it did, but the courts have interpreted it as notice that's reasonably calculated to let members of the public exercise the right to be present during the meeting. That's one reason why your BZA procedures lay out some notice procedures. We want to make sure that the public is aware when we get applications on certain things. But staff also publishes a calendar every year and will regularly put advertisements in the newspaper when there's going to be a Board of Zoning Appeals meeting where there's actually a matter on the agenda. The Act requires that we keep minutes and that they may be made available to the public. Again, staff does the heavy lifting in the minutes department. We'll produce the minutes and then you guys review and approve them. And then they're made available to the public. Another aspect of the Act is that votes have to be public. You cannot have secret ballots in Tennessee if you're a municipal governing body. So that means that you either have an aye or nay, where everybody says aye or everybody says nay, or you fill out a ballot and it's read publicly. So each person's ballot is read aloud, or we do roll call votes. Most of the time we do the roll call votes because it's just so much simpler and it keeps track of whether everybody's voted and keeps track of how they voted. So moving on, there's one other aspect of the sunshine laws that we're going to talk about, and that's the Public Records Act. We're going to talk about that pretty briefly. As you may know, all records of state and local government are available for public inspection by citizens of Tennessee, unless they're specifically exempted. So this means that records related to the BZA's actions are also public records, because almost everything that you guys talk about is discussed at a public meeting. So there's absolutely no reason why any of it would be confidential. Minutes are going to be public records, obviously. Applications, transcripts, the recordings of meetings, staff reports, any materials presented by the applicants or opponents, those are all going to be public records. One thing that you guys may not think about is that the materials that you guys get at a meeting and that you take notes on could also be a public record. I don't know why anybody would ever want to see that, but it's possible that somebody could come along and say, I want to see Joel Staten's notes from the meeting on September 24th. It's you just never know. That doesn't mean that you have to keep them, but if you do keep them, they become a public record eventually, or they could become a public record. All right, so the last topic we're going to cover, and we're going to do it pretty quickly because I want to be done by 12:20. So we will have our full hour of training. I'm very proud of us. Is conflicts of interest and ethics. There are a couple of sources for ethics law for city officials, and city officials includes you guys. By serving on the Board of Zoning Appeals, you have become appointed, uncompensated city officials. So under state law, there's a prohibition on any member of a board such as the BZA having an interest in any contract or work that is the subject of a vote before the BZA. Now, in a nutshell, what that means is that city officials can't have a personal pecuniary interest in contracts with the city if part of their official duties would be to vote for or superintend such a contract. That I'm telling you about that just so you have a full understanding of the sort of framework of ethics laws that governs you. That's unlikely to come up during your service on the BZA because the BZA doesn't really vote on contracts that the city has an interest in. You're voting on other people's interests. But it is something to keep in mind if you move on to another board or if you serve on a board in the county or anything like that. There's going to be that ethics restriction of not having a personal interest in a contract that you might have the responsibility to vote for. Probably the larger source of ethics restrictions for you guys is going to be in our city code, which is adopted by city council. It's part of the city code of ordinances. All cities had to adopt a code of ethics back in the 80s or 90s, I think, and Bristol was no different. So what the city code covers is things like personal interest in a matter that's subject to a vote. So what that means, a personal interest under the city code is something that would affect or would lead a reasonable person to infer that it affects the official's vote on a matter. And here, BZA members really can have a personal interest in something that comes before the BZA. Personal interest includes any financial ownership or employment interest. And so it also includes financial ownership or employment interests of your spouse, parents, step-parents, grandparents, siblings, children, or stepchildren. And just as an aside, this is all contained in the city code, and I'm happy to email you a copy of the code of ethics if we didn't give it to you, because at this point I can't remember if it's in your book or not. But it's fairly easy to find. And so I'm giving you the overview right now so that you can then go back later if you need to, if you've ever got questions, and look at it. So an example of a personal interest might be if someone that you know requests a variance for their property. Depending on the nature of your relationship, you might end up having a personal interest in that application. So if the applicant is a family member, you know, for example, your brother requests a variance on his property, or if the applicant is a supervisor at work, or someone that you have lent money to, any one of those people, if they're applying for a variance, you could have a personal interest in whether they get that variance or not. For example, suppose you're planning to buy a piece of property, but it needs to have a variance approved before it really can be used for the purpose that you want it to be used for. So you might ask the current owner to apply for a variance. That would clearly be a situation where you have an interest in that variance. So the city code does not say that that's prohibited. What it says is that you have to disclose that interest. And then you may recuse yourself, but you're not required to. Recusal means that you don't take part in the discussion or deliberation or voting. It doesn't mean that you just refrain from voting. In fact, many authorities recommend that you actually leave the room while this is being discussed so that you don't influence it. What I would hope is that even though the recusal is not mandatory under the city code, that any member of the BZA who believes they have a personal interest in a matter that's coming up for a vote would recuse themselves, because if the personal interest, you have to disclose it. And if it's a personal interest that you have to disclose, then it's going to be very difficult to argue that it's not something that influenced your vote. And going ahead and voting after you've disclosed that personal interest really does give anybody who opposes, the aggrieved party on the other side really has an argument that you guys have not voted fairly if there's a member who's got a personal interest at that point. However, it's not required. That's going to be up to you to make. That's a decision you're going to have to make under the Code of Ethics. So moving on to the next slide, and we will move through these pretty quickly. The Code of Ethics prohibits you from accepting money, gifts, or other consideration in order to influence your performance of an act or to reward you for performing an act. You are allowed to accept gifts that are consistent with the city's gift acceptance policy, which basically means that you're going to be allowed to accept things like t-shirts. If you go to a conference, you're going to be allowed to accept the conference swag that you get at the conference. If you win a door prize at a conference, you might be able to keep that. If those things ever come up, that'd be a great time to talk to me or Tim, and we can look at the gift acceptance policy and help you figure out what to do there. The city code prohibits disclosing any information that you learn in official capacity that is made confidential. It's unlikely that you're going to learn a whole lot of confidential information in this capacity because most of what you're learning is provided to you at a public meeting. But do keep it in mind, because I say it's unlikely, but that doesn't mean it couldn't happen. You are prohibited from using municipal time, facilities, equipment, or supplies for private gain or advantage. You are not allowed to make private purchases in the name of the municipality, or use your position with the city to secure any privilege or exemption for yourself that's not authorized by law. So, for example, a member of the BZA should not expect or request any special consideration when it comes to dealing with the planning department. So, for example, if you're submitting a site plan or house building plans, you're going to get treated the same way that everybody else who comes in is treated, regardless of your membership on the BZA. The last one is probably the most interesting one, or it may come up for some of you. The city code prohibits outside employment if the work unreasonably inhibits your performance of an official duty. So what that means basically is that if your day job puts you in a position where you are unable to vote on most matters that come before the BZA because you're having to recuse yourself or disclose a personal interest, then you should consider maybe not being on the BZA anymore. We obviously know that most of you guys have day jobs and that you are going to continue to work, but sorry, or you're not going to work, you're going to continue to be retired. But sorry, I should have thought about that. But your day job can't, we don't want you to quit your day job if you have one. We prefer that you retain your day job and give it your spot on the BZA for somebody who can do the job. Having said that, there are not a lot of jobs that I think would fall into this category. I thought a lot, and the only thing I could think of would be something like a surveyor who frequently testifies before the board on setbacks or something like that. That person probably should not be on the BZA. So that's the flying overview of BZA, what you guys do, what state laws is out there, what city law is out there, and here we are at the end of the training. Does anybody have any questions?
Yes, Danielle.
Have I scared anybody? Huh?
I've got one.
Okay.
Now, does the BZA board members have to file with the state every year like planning does for conflict of interest?
No, I don't think so. I think I've looked at that before and came to the conclusion that you did not have to file the same way that city council and PC have to file.
Yes, I looked that up just this past week because of that coming up, the annual disclosure, and it's city council and planning commission.
Yeah, I don't know why, but that's just
okay.
Yeah.
Well, just the last couple of years put it on there, so I didn't know whether to or not.
You'll have to do it, Joel, because you're on planning commission. You don't have to do it because you're on BZA.
And I believe those are due, and Sheriff can correct me, but the end of January, those disclosures have to be in. You can file them electronically or by mail, but we'll talk about that at planning commission. So.
Okay, thank you.
All right, are there any other questions?
No questions, but I want to thank you. It was really excellent training. Thank you.
Oh, well, you're welcome. And please feel free. And we did clock in at an hour, so I feel very good about that. You guys have honestly earned an hour of your BZA training today. But please feel free to reach out to me if you've got questions about anything, particularly the ethics side of things. I'm the city's ethics officer by code. And so if you ever have a question about whether you should is this a personal interest or not, I'm happy to work through that with you and help you come to a decision.
So is the next thing to do to ask for a motion to adjourn, or is there something we need to say before that about our next meeting or something to that effect?
Just a couple of items, Madam Chairwoman, if I may.
Go ahead.
You had early on the discussion about board training. There are 4 hours required during the year. This obviously is qualified as one of those hours. And they'll cover through the end of 2021 this first 4 hours. So there is an opportunity coming up Monday night at 5 p.m. We will be doing some training on property rights with the Planning Commission that I will make sure you all get invites if you want to join. It will also be recorded and you can watch that at your leisure if you want to do an hour of property rights training that the Planning Commission has to have. Y'all don't have to have specifically property rights training, but it would qualify for some additional training if you want. I will make sure y'all get the links for that Zoom meeting, or you can watch it, you know, at your leisure once it's recorded. So that is an opportunity coming up quickly. We will email you the PowerPoint that Danielle put together there. Sorry, Danielle, I did have that. I just didn't save the email. I saved it to my desktop, and so
Okay, Tim.
and then we'll also email you, as Danielle talked about, in the city code of ethics. We'll make sure you get that in an email also. So that's just some other items. Once again, we will not meet unless there's a case coming up, or unless y'all want to meet sometime in the upcoming months. There's a possibility for some cases to be in your purview coming up, potentially. We'll see how it plays out, and it's from some previous decisions by the previous boards. So anyway, that's all I have, Madam Chairwoman. I wish everybody a Merry Christmas and a Happy New Year if I don't see or talk to you before then.
So with that, thank you, Mr. Beavers. Does anyone have a motion to adjourn? Do we even
Move
need
to
that?
adjourn.
Was that David or Joel? I'm sorry.
Joel.
We have a motion from Mr. Staten to adjourn. Anyone want to second that?
Second.
Okay, we have a second from Mr. Goforth. So all in favor of adjourning?
Aye.
Aye.
Okay, sounds like a majority or unanimous vote. So thank you all, and we're adjourned.